The reenactment that you just saw was an actual case that I was an expert witness on early in my career as a program director. The imaging center, technologist, and patient's name were altered to protect the innocent, and maybe the guilty. The actual case took place in the late 80s, in the early days of MR, at an outpatient setting. The real technologist was a man, and the real patient was a woman. My students were so excited to do this reenactment, and I think they did a really fantastic job. Welcome. Welcome to Anatomy of a Medical Malpractice Lawsuit. My name is Ted Vanderlaan, and I'm a radiologic technologist as well as a licensed attorney. This was my first exposure to law in radiology, and being involved with this case was part of my inspiration to go to law school. In fact, the attorney that I worked with was a nurse who became a lawyer later. I figured if a nurse could do it, then why not a radiographer? It really was such a great experience, and I'm glad that it happened before I became an attorney, because they would likely never let me be an expert witness now. So before we get too far into this, I want each of you to think back on the video and write down what you believe the verdict should be in this case. What's your gut reaction on this? Should the technologist be found guilty of malpractice or not? If so, where did the technologist go wrong? And what should she have done? If not, why is she not guilty of malpractice? Does the patient have some culpability, or maybe all of the responsibility for harming themselves? So think about it and take just about 30 seconds to jot down your thoughts. Let's get started and have a little fun as we use this case to walk through the typical elements of a malpractice lawsuit. We will apply those elements to this case and discuss methods to mitigate exposure to a medical malpractice lawsuit in an imaging department. Of course, these can be applied to any medical malpractice situation, whether it be a physician or nurse, or in this case, diagnostic imaging. I really appreciate you joining this presentation. It's a bit of a primer on medical malpractice. Hopefully, you have had limited need to know about this topic, or you may be quite familiar with it from your own experience or knowing someone that has been. If you work in medicine long enough, you're likely going to brush up against some of these issues. Negligence is part of tort law that is considered by many to be rooted in English tort law. The term tort was used as early as the late 1500s. Prior to that, the concept of compensation for wrong dates back as far as Levitical and Roman law, though they used different names to describe it. It's found in what's known as common law and is civil wrong, meaning that two parties that obtain damages for wrongdoing. In other words, if one person does something that causes another person injury, either physical or otherwise, they must pay the victim for the wrong. And those injuries include everything from financial losses, physical injuries, intentional infliction of emotional distress, and in this case, negligence, invasion of privacy, etc. Negligence. a failure to exercise appropriate and/or ethical ruled care expected to be exercised among specific circumstances. This involves harm caused by a failing to act as a form of carelessness, possibly with extenuating circumstances. This comes from Wikipedia. Cornell Law School defines negligence as a failure to behave with a level of care that someone of ordinary prudence would have exercised under the same circumstances. The behavior usually consists of actions, but can also consist of omissions where there is some duty to act. For example, a duty to help a victim of one's previous conduct. And that is from the Cornell Law website. Negligence has 4 elements. They are duty, breach, harm, and causation. So we will explore whether the technologist had a duty to the patient, then breached that duty, whether there was actual harm to the patient, and whether the technologist's breach of duty was the cause of that harm. So what is duty? Duty is what's owed to the patient by the provider, and that is determined by professional standards. And in our case, that will be the American Society of Radiologic Technology and the American Registry of Radiologic Technology, and any state or local standards that apply. Also, duty is determined by the educational standards that we learn about in our curriculum, and those are governed by the American Society of Radiologic Technology and the Joint Review Commission on Education in Radiologic Technology. So we're going to go through a couple of examples from the American Society of Radiologic Technology Code of Ethics. So let's look at number 4. Number 4 states, the radiologic technologist practices technology founded upon theoretical knowledge and concepts, uses equipment and accessories consistent with the purpose for which they were designed, and employs procedures and techniques appropriately. Number 5, the radiologic technologist assesses situations, exercises care, discretion, and judgment, assumes responsibility for professional decisions, and acts in the best interest of the patient. And number 7, the radiologic technologist uses equipment and accessories, employs techniques and procedures, performs services in accordance with an accepted standard of practice, and demonstrates expertise in minimum radiation exposure to the patient and other members of the healthcare team. So, as we look at this, there are a couple things that come to my mind at least. Did the technologist, looking at number 5, did the technologist assess the situation, exercise care and discretion, and are they assuming responsibility? And number 7, where it says, in accordance with accepted standards of practice. So what is the accepted standard of practice when it comes to patient care in those situations? Now, let's have a look at the American Registry of Radiologic Technology Standard of Ethics. So you have the full page of them there, and now we will zoom in to read them more closely. So these should look familiar, and number 4 is the radiologic technologist practices technology founded upon theoretical knowledge and concepts, uses equipment and accessories consistent with the purpose for which they were designed, and employs procedures and techniques appropriately. Number 5, the radiologic technologist assesses situations, exercises care, discretion, and judgment, assumes responsibility for professional decision, and acts in the best interest of the patient. Number 7, the radiologic technologist uses equipment and accessories, employs techniques and procedures, performs services in accordance with accepted standards of practice. So now these should seem a little redundant to you, which is good. That means that we're consistent as radiologic technologists. So, as tedious as this might have seemed for me going through it, reading it word for word, that is exactly what they would have done in the courtroom when they're establishing whether this technologist had a duty to this patient. And I think that we can all agree that, in fact, the technologist does have a duty to the patient. Now that we have established duty, the question is, was there a breach of that duty? A breach is defined as a deviation from the applicable standard of care for the duty or the duty for the healthcare professional. And how is it proven? It's proven during the discovery phase of the case, and it's proven by medical records, orientation and employment documents. For example, maybe there was a orientation in MR where it talked about what to do with the patient's brass key after the patient locked their locker. Was there in-service training? Was there in-service training, for example, on what to do with a patient who has been in a procedure and being in a supine position for an extended period of time? We all learned about orthostatic hypotension. We also learned about vertigo, where a patient lying down for an extended period of time, even a healthy patient, could experience dizziness and the falling asleep of limbs. Also, during the discovery, they will pull out textbooks. They will find what textbook the student learned under, or whatever the current textbook on patient care and other educational material. They will also get testimony from the patient. Does the patient perceive that there was a deviation from the standard of care that the technologist provided? The technologist will also give testimony, and likely that testimony will include his or her training, their clinical experience, their onboarding and orientation, any in-service training, and also what is the standard for care in this practice amongst all MR techs, for example. And then you'll have expert witnesses. And with expert witnesses, it gets just a little bit tricky because you will end up potentially in a battle of the experts. Now, the question is, was there harm? So here, there must be actual harm. And this is fairly straightforward. and proven by medical records and testimony by the patient and the physician. For example, in this case, the patient had an x-ray done on her ankle and went to the orthopedic surgeon to be treated. The reason there's a requirement for actual harm to be proven is that it's much too difficult to prove in court if you can't demonstrate the actual harm. That is where there would just be the patient's word against the technologist, and way too easy to fake an injury. Causation. So it must be proven by a preponderance of the evidence that the breach of the duty owed the patient was the cause of the harm. So this fourth and final element is arguably the most complex. And preponderance of the evidence means that it's more than 50% likely that there was a breach of duty and that breach caused the harm. Now there's two types of causation. There's actual and proximate. So actual cause. Let's talk about the actual cause, and it must be proven that there is a causal connection between the harm and the breach. In law, we've called it the but-for test. The plaintiff's injury was a foreseeable result of the defendant's actions, or but for the technologist's actions or inaction, the patient was injured. And an obvious example would be if a technologist was taking a tabletop skull x-ray, for example, released all of the locks, and brought the collimator down on the patient's head. But for the technologist's action of releasing the locks and slamming the collimator into this poor patient's head, the patient would not have been injured. Now, of course, it's rarely that clear, but the cause portion is very fact dependent. And because it's not usually so obvious as the example I just gave, very often you will need an expert witness to prove and to get what we call the battle of the experts. Who's got the thickest resume? Who has the most experience? Who's got the most letters after their name? And it also may require prior medical history. And there's a term that's called the eggshell plaintiff, which can be applied, which means that you take the patient how you find them. So if the technologist in our falling down off the MR table situation had to take, if the patient already had a sprained ankle, the technologist would still have to take them how we found them, meaning injury and all. And they would have to prove that this injury made the sprained ankle worse. So thinking about the scenario in this case, the technologist put the key on the ledge. Then when the exam was over and the patient was sitting on the edge of the bed, the technologist said, "Patient, stay so you won't injure yourself." Took 2 steps away to get the key. Patient jumped off the table and twisted his ankle. So as we're thinking, was it the technologist stepping away that was the negligent act? Was it the patient's own intervening action of jumping off the table that caused the twisted ankle? More on that later. Now, it's time to get out your pencils or your pens so that you can impress the folks at home. There is a term called res ipsa loquitur. which means it is, and it's Latin for the thing speaks for itself. This means that whatever injury occurred would not have occurred without the negligence of another person, specifically here, a healthcare provider. If the thing speaks for itself, then the plaintiff may only need to prove that the harm that occurred and would not have occurred if it wasn't for the defendant's negligence. And it must be proven that there was no evidence of the actual cause of the injury, but that the injury is not the kind that ordinarily occurs in the absence of negligence, and that the plaintiff was not responsible for his or her own injury, and that the defendant or his employees or agents had exclusive control over the instrumentality that caused the injury, and that the injury could not have been caused by any instrumentality other than that over which the defendant had control. Now, I know that you believe that you think you understand what you think I said, but I'm not sure that what you heard is what I meant. So this is where I think many people get frustrated with the law, because the language seems to be obfuscating sometimes at best. But what this really means is that the patient didn't harm themselves, they couldn't have harmed themselves, but the harm was caused and somebody other than the patient had absolute control over the situation. So to help explain this a little bit, we're going to go back to 1863. The seminal case on res ipsa is Bryn versus Moodle. It's an English case from 1863 where poor Mr. Bryn is walking down the sidewalk and a barrel of flour rolled out of the storage and struck him on the shoulder and head. It knocked him out cold. The owner said that he had nothing to do with it and he wasn't even on the premises. All the workers said they had nothing to do with it. They weren't even in the upstairs storage area. And originally, the case was dismissed. However, it was brought back because the judge had held that Mr. Bryn should not be precluded from filing a lawsuit against Mr. Moodle because the owner had exclusive control over the storage area. And the only way a barrel could roll out and strike a pedestrian would be that if there was negligence in some way. The thing speaks for itself. All right, so we've talked about actual cause, and now we're going to talk about proximate cause. So proximate cause, when considering all the relative facts, the actions were the legal cause of the patient's injury. So you have to consider pre-existing conditions, you have to consider the patient's own negligence, and you have to consider superseding as well as intervening cause. So in the case before us, one might consider that the patient's own negligence was the proximate cause of her injury. The technologist helped the patient up, told the patient to sit on the edge of the bed so that she can get her balance, and checked to see if she was okay. Then turned and walked 2 steps away to get the key, at which time the patient, and this is in her own testimony, and on her own volition, knowing that her leg felt asleep, jumped off the table and twisted her ankle. So here we have to ask, was it the technologist's negligence for stepping 2 steps away to get the key, Or was it the patient's own negligence that caused the injury? Was it the patient's negligence that was the proximate cause of her injury? So at this point, let's check in and see if you've changed your mind at all about whether you think the technologist was at fault or if the patient was at fault, or maybe they were both at fault. So while we're thinking about who's at fault for the twisted ankle, let's move on to a little bit about the law. There are two types of law that we'll discuss, criminal and civil. In malpractice, which law typically applies? Typically, malpractice falls under civil law. That's not to say that crimes don't occur in medicine or in diagnostic imaging, but they would have to be statutory violations like assault or battery or false imprisonment and brought forth as a criminal matter, and we will discuss the differences now. So there's no case in recent memory that brings the striking differences between criminal and civil law. Enter stage left, O.J. Simpson. The first trial was criminal, and it was for the murder of the first trial was criminal, and it was for murder, and the title was The People of the State of California versus Orenthal James Simpson. Notice the title. It's The People versus. The second trial was a civil trial for wrongful death, and it was brought by the families of Mr. Goldman and Miss Brown versus O.J. Simpson. And the title of that was Goldman and Brown versus O.J. Simpson. Keeping this case in mind, let's go through some of the differences between criminal and civil law. This slide shows the first of two charts that discuss the differences. So let's talk about the purposes of criminal law and civil law. So the purpose of criminal law is to punish the criminal, and in civil law, it is to compensate the victim. The balance of the defendant's wrong and the victim's injury. The emphasis on criminal law is the defendant's moral wrong, not the victim's injury. And the opposite is true in civil court. The theory of the offense in criminal law is that the crime is an offense to society. In civil law, they only care about the victim's injury. The initiating party in criminal law is always the state. The people versus. And in civil law, it's always the victim who is the plaintiff. Representation in criminal law is the prosecutor. Representation in civil law is a private attorney or self, which is called pro se litigant. In criminal law, there is a right to a jury trial, as found in the Sixth Amendment. And sometimes in civil law, there is a right to a jury trial, but often not. The defendant has a right to counsel in criminal law. The defendant does not have a right to counsel in civil law. And the deadline on action are in both criminal and civil is statute of limitations. Now, on capital crimes like murder, there is no statute of limitations. That's why, for example, when Ronald Reagan was shot by Hinckley, He could not be charged with murder. However, once Reagan passed away, then he could be charged with murder. In civil law, typically the statute of limitations is 2 years. Now there are a couple of exceptions. So when a minor is injured, they have 2 years after the age of majority for that state to file the lawsuit. And more recently, for specifically for childhood sexual crimes, and this came out quite a bit with the clergy sex abuse cases, where many, because it's such a deep psychological injury, many people suppress that that memory of what caused the harm. And so there have been cases in several states where they have allowed the victim to proceed as long as it was 2 years after they became aware of what occurred. Continuing on this, on these charts, the category of responsibility is guilt, and the category of responsibility in civil law is liability. Now, here's a big key: standard of proof. Standard of proof in a criminal law is beyond a reasonable doubt. So if you remember the pictures a couple of slides ago of the O.J. Simpson case in the middle, where O.J. Simpson was putting on the gloves, all the dream team had to do was to put reasonable doubt in the minds of the jurors. And the phrase that they kept repeating is, if the gloves don't fit, you must acquit. And in fact, they demonstrated whether there was some shenanigans going on or not, we can't prove, but in fact the gloves didn't fit. So that was enough reasonable doubt for his being found not guilty. And in civil, it's by the preponderance of the evidence. So that means more likely than not, more than 50%. And the gloves fitting or not fitting did not come into play in the civil case. It was just found that more likely or not, O.J. Simpson was responsible for the deaths. Judge. So the judge in a criminal court cannot direct a guilty verdict. The judge in a civil course can. The fate of the defendant suffers punishment, fine, imprisonment, and in civil court, the fate of the defendant is to pay compensatory damages or punitive damages. Interestingly, even if they're found guilty, if they have no money, they can attach future earnings, or they can declare bankruptcy, which can completely relieve them of that responsibility. So the fate of the victim in a criminal case is ignored. And the fate of the victim in a civil case is compensated. Appeals are available in criminal law only by the defendant because of double jeopardy. The prosecutor cannot try the case again, cannot appeal it, because they had their one shot and that's it. In civil law, either the defendant or the plaintiff may appeal. The defendant's testimony may not be compelled because there is a privilege against self-incrimination. However, in civil law, you can compel the defendant to testify. And this is really because the penalty is so potentially so great that a defendant cannot send himself or herself to a death sentence. There are affirmative defenses on both criminal and civil. In criminal, there's excuse or justification, and in civil law, a couple of affirmative defenses are immunity, consent, and privilege. All right, let's move forward specifically here and find out what are the steps. How does this whole thing start to get processed? So the first step is that the victim files a complaint. Then the defendant or defendants are required to answer that complaint. If they don't, then the victim will get a default judgment. So it's rare that a complaint does not get answered. Then there is the discovery process, which is extremely lengthy, followed by a trial. So the complaint is filed. Often the defendant has no idea they're being sued until they receive the complaint. The complaint must be sufficient enough to show the level of proof that the defendants were properly served. It must be filed within the 2-year statute of limitations. And the complaint must be specific enough that the judge that's reviewing it can identify that there is, if all of the claims are proven, enough to move forward with discovery. Then the defendant has a specific amount of time to respond to that complaint. And the response is usually very, very generic. So, for example, they will admit to all of the things that are obviously true. Name, where they work, where they went to school, their background, their medical training, their license number, etc. However, they will deny anything that is related to the case, typically, or they may admit in part and deny in part. So this closes the answer loop, which allows for the next step to go forward, which is discovery. So discovery can be an extremely lengthy and tedious process because everything that you need to put on your case must be brought forward during the discovery process, and it must be shared by both sides. Often the discovery is overbroad, and there's a lot of wrangling between the sides and the judge as to what will be allowed in discovery. So traditional discovery is for paper documents. Usually the defendant will get a letter from the opposing attorney ordering them to freeze all documents related to the case. The defendant will also reciprocate and send a letter to the plaintiff's attorney asking the same. Now, in the world of electronic medical records and electronic communication, digital photographs, radiology information systems, hospital information systems, RIS and PACS, all of that becomes discoverable. And an e-discovery freeze will be demanded that all electronic documents, access logs are frozen, and all electronic data on all servers will be frozen for both sides. The interesting thing about electronic discovery, or should I say one of the interesting things that people tried to do is they attempt to delete electronic documents. Don't try it. There are breadcrumbs everywhere, and every time you have logged in, and whoever is logged in, even if you cannot see the file that was deleted, there will be a log that says the file was deleted. Also, there's chances, because of backups, etc., that there will be multiple copies of the files in other locations. Now, there's an exception to the discovery rule, which is called work product. So once the answer has been filed, any work product and documentation between the attorney and the defendant, or the attorney and prosecution, is not discoverable. Regardless of that, it's essential that both parties check with legal counsel before deleting or destroying anything. As often happens, the case goes deeper, and both sides find out that there's things they don't want the other side to know about. So the temptation to start deleting records becomes too great, and they can be found in contempt of court if it is discovered. Now, those of us who romanticized the law profession when we were getting into law school and in law school became a little bit disappointed in our legal writing class when our instructor very happily said, and by the way, only about 2% of the cases that you work on will ever go to trial. Now, those who hated public speaking, they were relieved and they were happy to bury their noses in the books and write. And those who wanted to have the glory and the glamour of cross-examining a witness and in front of a jury of witnesses' peers, they were a little disappointed. And often what happens is as discovery goes along, both sides find out that they probably did not want to proceed with the case after all. So let's talk a little bit more about our case. As the expert witness, I had an opportunity to read all of the depositions of all of the litigants and was deposed myself as the expert witness. My expertise was on radiology education and how the education of an X-ray tech could have allowed for an outcome for this patient. So I also read the testimony of the patient, and the patient was actually quite belligerent about it all. She had a known back problem. She described her leg falling asleep on frequently. She described the radiculopathy under sworn testimony, and was cross-examined about what she did when her legs fell asleep or her foot fell asleep. And she knew how to get it resolved. She would walk around, supporting herself. And her testimony actually was that by the end of the study, which was about an hour long, she was just sick of being on the table and she was getting off. She didn't care who said what, she was getting off that table. The technologist's testimony was basically that the patient came in, the machine had to be rebooted, the patient did spend extra time on the table, and the exam was finally completed. The technologist sat the patient up, told her to stay and get her balance, and he stepped over to get the key, and the patient popped off the table. In fact, the patient also admitted that he did tell her to stay, and then he stepped over to get the key, and she jumped off the table. They did depose the doctor, who was a radiologist on staff that day. The only thing the radiologist did was to testify that he came in, examined the patient's angle, and recommended an X-ray. The patient's doctor was deposed, and he described symptoms and had suggested treatment, and she completely recovered. That would be an interesting time Now, knowing a little bit of the history, to write down what questions you might have asked any of the witnesses. Now is the moment of truth. You are the judge or the jury. You've seen the case, you've formed an opinion. Maybe you feel like the technologist should never have left the patient's side and therefore was negligent under the code of ethics as our professional organizations. Maybe you believe the patient is completely responsible because, after all, even given her own testimony, she admitted that she jumped off the table. So wouldn't this make her responsible for her own injury? And in the end, this case went the way of most cases. They settled. I don't know what they settled for because that was confidential information. So what can we do? It makes it really important for us to look at our own departments and look at our own education process, and for people to review departmental policies. We want to protect the patients from risk. We want to protect the technologists from liability. We want to kind of look at ourselves and see how we act and what liabilities we create as part of our practice. And an example that I thought about as I was going through this, it's like every time we take an x-ray of a patient, we step away from them. It is part of the way we do business. So how can we mitigate that? So I just want to thank my amazing students, Rose Wilson, Rui Martins, and Mona Chakre. And thanks to the Santa Clara Imaging for their after-hours use of their facilities. These kids did a really great job, and I had fun doing it.